transfer agreements for joint marketing and so take it away, Charlie O'Brien.
All right. Well, thank you very much for having me today. Interesting to go around the room and hear what everybody's doing. It's just a wide variety of different things. So, we're charged here, we're talking about how to evaluate your innovation. And I thought,
Can we do it?
ask you to flip, excellent. So, just let me give you an outline of what I thought I'd go through today, and Mike and I talked about this a little bit as well. First, just to kind of level set and talk through kind of the overview of different categories of IP. I know patents are probably the main focus here, but just so everybody kind of understands the interrelationships between patents, trademarks, copyrights, trade secrets. Quickly, we'll go over that. Talk about different monetization strategies. And you own your businesses, you have patents that can be either issued or published or that you're going to be filing. And how do you think about monetizing that? Are you going to license it? Are you going to sell them? Are you going to get finance, use them for financing? And there's a whole many different ways to monetize the patents. The way you monetize those patents will ultimately determine kind of the way in which you will try to value the patents. So we'll talk a little bit about that. Then we'll go through and talk about the couple of different most typical valuation type of methodologies and kind of walk through each of the three. And the good parts, the bad parts, what you may want to do, what you may want to stay away from. And then the America Invents Act. I thought we'd end with just explaining a couple of different areas that has come up in the AIA and how those different laws may affect valuation. And then we can go through a question and answer. If anybody has any questions while I'm talking, please just raise your hand, and it'd be great just to kind of talk you through while I'm walking through this. All right.
That didn't work.
That's just us. You can skip that one. So, there's four categories of intellectual property: patents, trademarks, copyrights, and trade secrets. Each one's a little bit different. Patents cover ideas. You have protection over ideas that are useful, novel, and non-obvious. Go through the patent prosecution process, which it sounds like you're all intimately familiar with. Patents don't give you the right to make your products, practice your invention. It gives you the right to exclude others from doing it. And that's a key concept that we'll talk a little bit more about as you get to valuation. But that's something that some folks miss in understanding patents. Trademarks, typically words, symbols, names, indicates a source of goods, differentiates your source of goods from other goods, and it prevents others from using a confusing similar mark. Branding, essentially. It sounds like, I assume some of you, when you're coming out with different products, you're going through this process of branding, coming up with trademarks, and trying to differentiate your goods from others through branding. Trademark is a use-based right. You got to use it or you're going to lose it. Patents are not. You can own a patent, but you can never do anything with it. But you still own that patent for the time that it is in existence. With trademarks, every couple of years, you have to keep telling the Patent and Trademark Office, yes, I'm still using this. Give them evidence that you're still using it. So it's a use-based right. Copyrights they don't cover ideas, they cover expressions, books and songs, and things that are embodied in tangible mediums. They do cover software as well. And copyrights typically come with what's called a bundle of rights. A couple of them are, you have the right to reproduce, author a book, you can make copies, you can distribute it, you can prepare derivative works from it. But it does not cover the concept, it doesn't cover the idea of what's in a book, it covers that particular expression of what your idea was. One thing I wanted to point out at copyrights, I often hear people say, I own this invention because it was a work made for hire. It's work made for hire only applies to copyrights. If you are developing an idea, you bring in a third party who helps you, and that third party improves on it, or somehow you now jointly develop something. It's not a work made for hire. You don't own that idea because you brought him in and he's working with you. It's just purely a copyright concept. So if you're bringing in other folks to work with you, from a patent and idea protection standpoint, you have to have agreements in place that say whatever you're going to do for me, if you come up with an idea, you assign it to me, I own it. You can also cover copyrights and that sort of thing, but you have to have those agreements in place. Trade secrets derive their value from being secret, not being known to others or readily ascertainable by others. And this is where when you're thinking and developing your ideas, you may think through this process, and you should think it through. Do I patent it? Do I keep it as a trade secret? What gives me more value? There's advantages and disadvantages, but that's a different topic. The AIA, when we get there at the end, has changed things a bit that with respect to trade secrets that may have some effect on valuation. And you have to take reasonable steps to protect your trade secret. So those are the different categories of general categories of IP. So you have your idea, you have your invention, you have your product or your process. How are you going to monetize it? What are you going to do with it? There's a couple of different ways. Yeah, I'm sure you've all kind of thought this through. You can do things that are internal. We'll walk through some of those. You can do some things that are external and monetize that way. And then there are hybrid, different hybrid ways to exploit and monetize the technology. All those strategies are up to you. You run your business. But how you monetize that in any of those three ways is going to affect the inputs that go into valuing your IP and the assumptions that are going to go into valuing your IP. So let's take a look at a couple of the different types. In the internal exploitation, you have a patented product, you're going to sell your product. Now you have a protected product. So you go to market with that and you have patented features. Again, so this is, now you have your patent, you're selling your product, but the patent, again, does not give you the right to make that product. It's just the right to exclude others. So you could be selling your product, you could have a patent on your product, you are still open to being sued for infringing some other third-party patent. Anybody have any questions on that?
Is that why you're emphasizing this? Oh, I'm sorry.
Yeah.
It's not clear at all.
No.
Is that specifically why you're emphasizing this freedom to operate, specifically the fact that you could inadvertently be infringing somebody else's patent?
You absolutely could be.
Is that the purpose of that?
Yeah. So when you decide the way that I'm going to monetize my patent, I'm going to license it, I'm going to make a product, and I'm going to sell that product. You need to understand that sale, that manufacture of that product could give rise to third-party claims of infringement. So you may want to do what are called freedom to operate searches, see what other patents are out there, see what you're up against. And you can actually do this kind of earlier in the process before you're getting your patent, and maybe in parallel with getting your patent, looking to see what else is out there. You may want to tweak what your product ultimately is, so you're staying clear of those third-party patents. So also, when you're going to exploit it in that way by selling your product, you have to think, who am I going to sell this to? What is my product? Is it inherently dangerous? What is the seller going to ask of me? Are they going to ask for indemnification obligations that if it harms somebody, I'm going to have to pick up that defense. I'm going to pay those damages. If it infringes, then I'm going to step in and indemnify that buyer. Yeah.
Business insurance, right?
Very difficult to get patent infringement insurance. Yes, you can get business insurance.
For liability.
Yep, absolutely. But just as you're thinking through how you're going to exploit your product, just one concept to think about. But you're right, business insurance would cover that. Patent infringement insurance, there's only one company that I know of in the US that actually offers it, and it's very expensive. Yeah.
just looking at your caution up there again. So has the patent office issued patents and then later on issued patents and it turns out that they were for the same thing? Is that-
Probably.
I'm just asking. Yeah.
So, you can have a patent that covers your product. Let's say I'm making a chair. My chair has, or it's a stool. Let's say I have 4 legs and a seat. That's my patent. And somebody else comes along and makes a chair with a stool, a seat with 4 legs, but they put a back on it. Now they've improved upon it. If I make my improved product with the back on it, I'm infringing the other patent because I'm making a stool with a back on it. So I've made the improvement, but I'm still infringing the first patent. So that's why it's a little confusing.
be careful.
It's kind of counterintuitive. So
But that means the patent office decided back was novel enough to give it a separate patent. So there is a distinguishable thing about it from the patent office.
assuming the patent office, in that example, looked at the base patent of the stool and said, yeah, you added it back to it, that's not obvious, it's novel, yes, you get a patent over it. That doesn't mean, since you have the patent for the improvement, that you can actually make it. You can't. You have to go to the stool guy and get a license from
But
him.
you can't put the back on the chair if the other guy owns the patent for the seat and the rest of it.
You have to go to the stool, the guy that owns the stool patent and get a license.
Yeah.
Yeah.
The guy who owns the stool has to cause get a, if the guy who owns the stool figures out that, gee, you really need that back to this thing, and he puts the back on it, then you'd be infringing.
You gotta go to the guy with the back.
Yeah.
And
You
then-
gotta be careful how he improves it,
Yeah.
he may not even be able to improve his own invention.
Yes.
Yeah, well, and ways to think about that is if you put a lot of information in your spec, and maybe you have the idea of the back in your spec, the stool patent, you may be able to invalidate the patent with the back, because it's already in yours. And you may want to file continuation, so if you start to see those things in the
But in
future,
this case,
you can add the back.
in this case, it would be too obvious.
Well-
Somebody would back in the stool, on the stool, so he would violate the other guy's patent.
Depends what's bad, the patent office happened to say, yeah, it's not obvious. What's that?
I say, you would know that, right?
You would know,
Well, you would know that it's a very obvious thing to put back on the stool.
you'd be surprised.
And that's just an example.
Yeah, I mean, that's just an example, that's just conceptually, that's how it works.
I would just add from experience that there's a much less tangible reason that you probably offer this caution, and that's that the patent system is so overwhelmed, and there's usually a primary investigator, a primary prosecutor, and maybe a couple of other people as a supervisor, maybe altogether 3 people look at your patent, and it's so complex, ultimate, and their own pressures they have to produce, and so you might get that patent. And they could very well have overlooked something that you didn't find, that they didn't find, but somebody else out there will find if it comes down to brass tacks. And so it's something that if there are situations under which you can't possibly do enough diligence
No.
really to
You can search
ensure your protection.
forever. I mean, it's an endless process. You're absolutely right. They're under their own pressures, they're understaffed, and that's why they rely on the inventors they have a duty, as you all know, to disclose prior art that you know of. You're the inventor of the chair with the back, you know about the stool patent, you have to send it in.
That's why a good extensive patent search is a very valuable tool to do if you're an inventor. Just because, beware, just because your patent issued doesn't mean that somebody won't try and invalidate it later if it's not strong enough.
Yeah.
So
Great point. It
don't
is.
just rely on the patent office to do the patent search for you. Sometimes you
It
have to.
strengthens your own patent to get that stuff before
The
the
strength
patent
is in
office.
the number of claims you get.
What's that?
The strength would be in the number of claims you got on the patent. There's only one frivolous claim, it's not a strong patent.
Yeah, I mean, you want to have more than one independent claim, sure, to increase the breadth of it.
I go back one slide to the copyrights. Let's say 2 people write a movie script.
Yeah.
Who owns the rights?
You each own your copyrights. The question becomes, Did you know about, who knew, did either of those two know about the other one?
No, the team rights.
Oh, the
It's the
team
team
rights.
rights.
Okay.
Is it 50-50 or one guy does 40%?
If they both work for Fox Studios,
Mhm.
Fox owns it because they've signed agreements. But if they're joint, if they're co-authors, then it's jointly owned, unless they have an agreement that's, that makes it otherwise.
An actual example, my daughter's a writer and she sold scripts. She's writing one with a colleague now who has some mental problems and she'd like to put him on the side, sell a script, and I don't know if there'd be some vituperation from the other side.
Yeah, the easiest way is, if he's gonna be out of the picture, is to have him sign all of his rights over, so she owns everything.
You brought up independent claims.
Yep.
What I encountered was that the patent office split the patent into two separate because the claims were independent. So
Have a
there was a
restriction.
series of dependent claims that were
Two
allowed,
different classes.
and there was other statement that was considered unrelated independent claim, and so they told me to remove it.
Well, it sounds like they may have had a restriction requirement, you know, if it's two different areas that they're gonna search, they may require you to restrict out,
That's what they did.
and that's not unusual. And you can still go after those other claims, just for that particular application, they're going to examine those particular claims.
So I hold 10 patents. One of the patents in the technology I have now, the notice of allowance from PTO say the prior art failed to provide like an instant application. So including my prior work in the field. So what's exactly mean? I have the patent was issued. You know, prior art failed to provide like on the
What's in your claims?
what's in my claim.
Yeah, so they've looked at whatever you've submitted, and they have
Yes.
come to the conclusion that it's,
There's nothing.
your claims are novel or non-obvious over what you submitted. So that's when they issued the notice of allowance. Yep.
Thank you.
All right. So that's direct licensing. Let's go back to these are the kind of the external ways you can exploit things. You don't have to sell the product. You have a patent. You can license others to make it. You can split that up by fields. You can split it up by territories, exclusive, non-exclusive. The broader your patent is, if it crosses over different application areas, if it has automotive applications and aircraft applications, you can split those fields up and license it out into different areas. A very lucrative way to monetize your patent. Indirect licensing, you probably have all heard about the non-practicing entities. They go out, they bundle up, they buy up patents, or they sell the patent, or you can license it to these types of entities and allow them basically to start their own licensing campaign. You get a piece of the pie, whatever comes in the door. You can sell the patents, you can litigate the patents, you can assert the patents on your own to exclude others from the market. And sometimes, I say the low barrier to the, to the market, not the market, may necessitate litigation. If you have big competitors that can easily get into the market, but your patent's pretty expansive, you may have no choice but to litigate the patent. You're just going to enter the market, take the chances, knowing that you own your patent. You're a small company. It's the way of the world. All right, you switch. It's a couple of hybrid things you can do. You can cross-license with third parties. You have some IP, they have some IP. Maybe they're threatening you, you're threatening them. You can come together, join forces to some extent, cross-license each other, go out into your respective own fields, and you can share royalties. There's a ton of different ways to kind of split that up. When you do that, you have some antitrust issues you need to be aware of. If you're fixing prices, it starts to get a little bit hairy, so you need to pay attention to that. But in general, cross-licensing is just fine. You can jointly develop technology. If you're about 80% there, but you need the extra 20% from somebody else that has expertise, you can join forces. That's where you really need strong agreements that talk about the ownership and who can use what, where, and when. It gets very complicated in an IP ownership setting. So those are the kind of different ways that you can monetize things.
I'm sorry.
Yeah.
And to follow on this gentleman's question here, when two people do things together, they always say you should have some sort of agreement in advance so you know who owns it. That's also true, I would think, in this joint development type of activities. There has to be some agreement so you know what's the 80 and what's the 20.
Yeah.
What constitutes a proper executed contract between just people who are working together? I mean, can it be a napkin? Does it have to be a notarized document? What constitutes the
Doesn't need
real
to be,
thing?
doesn't need to be a notarized document, it needs to be a writing. Doesn't need to be under seal, it needs to be a writing.
Signed by both?
And even in the IT world, it doesn't need to be in writing. What happens is, if you're gonna work together, absent an agreement to the contrary, if you both come up with something, you jointly own it. So you don't, technically in the patent realm, you don't need an agreement. You should have one, because in the US, if you don't have an agreement, you're jointly working with one another, you jointly own it, you can exploit it however you want. You don't have to account to the other owner, you don't, or have to go back and talk to the other owner. What you can't do is you can't exclusively license it because the other person jointly owns it. So that's one limitation. But you should have an agreement.
Because the other person who jointly did it with you could turn out to hate you the next day. And
Right.
go out the other side of the country and go do whatever.
Well, there's all sorts of other things that go into it
And
as
they
well.
can.
Because when you work with somebody, you bring your own background knowledge, they bring their own background knowledge. So now you're mixing background technology with what you're gonna develop, and can they use what you brought to the table, your background technology, to exploit this jointly owned IP? Do you mind? Do you not? Do you want money for that? So you have to work through all that different kind of calculus on how those joint development relationships will work. So you're right. You have to have an agreement.
So I'm sorry, I have one more question on this. And then many times when you're doing something, you bring somebody in who's an expert, the way you contract with them is to give them a non-disclosure agreement. I'm gonna tell you all my stuff, you sign this thing, don't tell anybody. Is that enough of a contractual obligation that a lawyer would say, I heard you told somebody you should pursue it in court or something like that? Or is that just paperwork?
Here's what I tell my clients. If you're gonna kick the tires with another party, another person, another company, you need a non-disclosure agreement. But when you decide to actually work together, you gotta do more than the non-disclosure agreement. All the non-disclosure agreement does is protect confidential information. It doesn't typically talk about who owns what, who's gonna bring technology to the table. That's where you get into the joint development aspect. So NDA you need up front, but when you decide to work with that company, you gotta have more. That's what
Thank you.
my advice.
Can I ask a question?
Yeah.
So there are a lot of international students who are working on campus with industry. If they sign a non-disclosure agreement and then go back to their country, is it binding there?
Sure, it's enforceable here, assuming it has venue here. You can go to a court here and enforce it. You're going to have to chase them down. I mean, if it's a trade secret that they're now taking the other side of the world, you got to chase them down. But yeah, you can enforce it here. What your remedy may ultimately be is pretty questionable. All right, let's move on. So a few more things before we get to the different kinds of evaluation. So, you got to ask yourself, what's the purpose of evaluation? Why are you doing it? Is it for you're going to license the IP? Are you looking for financing? Are you going to sell the patent? And usually, depending on what the purpose is of the evaluation, will dictate kind of the rigor of the exercise of evaluating. If you're going to have significant financing, if you're going to do evaluation for litigation, definitely you're going to do an evaluation for litigation on reasonable royalties. You need an expert. You got to have expert reports. Typically, a CPA is going to come in and put together a 100-page report on how they got to different royalty rates and the monetization and the value. Another important aspect is your valuation date. And I have the Shark Tank issues down here. I see that. It's a great show, and people go on there all the time and they say, I have a pending patent application. My company's worth $100 million. Anybody can have a pending patent, just file it. So it's, if I'm valuing my pending, if I have a pending patent application, but I'm not valuing it as of today, I'm valuing it as an issued patent that's commercialized, that is now I have a revenue generating product way in the future. And they always come down on people that value things at the wrong time. So you have to look at that. What day am I looking at? Is it commercialized? Is it generating revenue? Those types of things. All right. So there's 3 typical approaches. It's all sorts of different kinds, but there's 3 typical ones that I see. Cost approach, market approach, and income approach. From the easiest degree of work down to the most work. It's kind of in the order that they go. All right, so let's take a look at the cost approach. So what does that mean? That basically says a buyer is not going to pay more for the asset than the cost to replace it. And think about this kind of in the concept of I'm going to buy a TV. I'm not going to pay more for that TV than I'm going to pay for the other one that's sitting next to it. In the types of, in the IP realm, the types of costs that you look at to go through this approach, what you would think, R&D, third-party service fees, paying your lawyers, paying the patent office, testing, regulatory approval, capital investment costs, and lost opportunity costs. You're now focusing all of your time on this particular technology. What are you not doing? What are you losing by not focusing on other areas? The problems with the cost approach are obvious, I think. There's a couple. There's no relationship between, or very little relationship between the cost of the asset and the revenue that asset can generate. And so the revenue of the asset can generate depends on the chosen monetization mechanism that you're thinking about. So that's why I said in the beginning, depending on if you're going to do it, if you're going to license it, if you're going to sell products, those are the different inputs to this type of thought. Second problem is the asset may not be replaceable with an equivalent. You come up with a concept that's novel, you got a patent on it, by definition, it shouldn't really have equivalent type of technologies. I know there are different technologies. There are similar technologies that do similar things, but it's unusual for the most part to be able to say this technology is so close to mine that the cost that it's going to take to get to the other one is X, Y, Z, and I'm done. So I look at it as something that's just kind of provides you with very much just a base, a rule of thumb, kind of a quick concept. Here's what I put into it, here's my costs. It can't be less than that, so I can at least have to get my costs back. Can you go back one?
Yep.
So where it may be useful, so you have your pending patent application. Maybe you don't even have a patent application yet. Very early stage, it's really unclear what's going to happen in the future. If you're going to have a product, you're going to have buyers, you're going to have any interest. Maybe you want to look at the costs and say, here's what my patent expenses are, and here's what it's going to take to bring it to market. And that's, at least at this point, at this date, here's my value. And if the barrier to market is low, maybe another way useful way to use the cost approach. All right. So the next one is the market approach, not too dissimilar from the cost approach. So the premise is the buyer is not going to pay more than what another buyer paid for an equivalent IP. So if you're going to look at this type of valuation technique, you're going to look at what is my asset, what else is out there that is in fact comparable, what other market or what other product is comparable, the type of protections that I have, is that the equivalent type of protection that's in that other type of asset. If I have trade secrets and that's the way I'm protecting it, should I be comparing it to patent technology that has a fixed time to it, or should I be comparing it to something else? The size of the market, the forecasted growth for the products or services, are they the equivalent? Is your product, an electronic device that's got a life cycle of 3 or 4 years? And you don't want to compare that to a pharmaceutical that's it's going to have a 20-year lifespan. And in comparing two different markets, what are the different bargaining positions? Is yours the same as the person in the other market that would be negotiating those agreements? So problems with the market approach is there may not be an equivalent asset out there, not equivalent enough to really go through this process. Same issue with the cost approach. The more fundamental issue, it's hard to go out and find transactions and agreements that you can see all this data and compare it. And even if you can find that type of data, to find something that then matches your particular market is even less likely. So just want to point out, LES, I'm a member of the Licensing Executive Society. They, every couple of years, come out with a published royalty rate and deal term survey. They do it in different market segments. They just came out with one in the life sciences. And they survey the industry. For the life sciences one, I think they had about 180 responses. They used about 140 or so of them. And they break it down into all different types of parameters. What type of technology, what were the general royalty rates, where did the royalty rate kind of, what was the maximum royalty rates, fields of use, anything you can imagine. So if you can match up your technology to something that's close to the high technology, the energy, the life sciences, it does give you a good bit of data. So that's in the Securities and Exchange Commission. Any publicly traded company has to file their material contracts. They're all publicly available. The problem is all the financial stuff is stripped out. So,
You go back one?
yeah. Go back one?
Nope, that's not it.
Okay. But there are other databases, but in general it's difficult to match this up.
What does LES stand for?
Licensing Executive Society.
Do you happen to know what they? Are you a member of that group?
Their annual meeting is in October down in Manhattan. So they're all over the
Is
country.
that patent attorneys or is that inventors? Or
It's a lot of business development people. It's lawyers too, but less lawyers, more business development people. It's a lot of pharma companies. For whatever reason, it's pretty pharma heavy, but it's a great organization. It really is. A lot of good information. If you go to their website, some good stuff. So the income approach. This is the most rigorous. Needs a lot of data, but gives you maybe the best result. Valuation is subjective. It's whatever someone's willing to pay for it. But the premise of the income approach is the value of the asset arises from the expected future revenue and benefits flowing from the asset. How much cash, how much money can I make on this, depending on how I'm going to exploit it. Looking at it another way, it's the sum total of the expected cash flow over some period of time, and looking at it discounted to today. So let's walk through this. Some initial parameters that you want to look at. Calculation of the amount of future cash attributable to the asset. If I'm going to license this out, realistically, what are my royalty rates going to be? What are my forecasted amounts that I can, the sales on this that my licensees may make? Is it exclusive? Is it non-exclusive? What's the life cycle? How much revenue is going to come in? But how long is it going to come in? How long is this money going to make? That goes to the life cycle. The likelihood and risks around realizing that money, litigation, invalidity challenge is the strength of your patent. And then in the end, taking into a lot of different, information, what's the discount rate to get that value to today? So let's, yeah.
What does that discount rate refer to? How is that, I mean, what are you discounting? In other words, the future dollars, are you talking about inflation, or what are you?
Kind of
what is
taking
that
the
concept?
future value and putting it in present day. So if I'm saying over the life, it's gonna be $10 million, I'm gonna make $10 million on this. Then it has a present day value. If I put $5 million in something that, some vehicle that's gonna make 5% over the next 10 years is gonna get me to 10 million. So my present day value is 5 million. But in this instance, it takes into account a lot of different data. And I did an evaluation done by an evaluation expert for a large client of mine who went through this process, and it was a 120-page report. Most of it focused on trying to figure out the discount rate, and it's usually it's something that a CPA, a skilled CPA that does this, goes through that process.
We're missing the principal question here. How long does it take to get a patent on average these days?
Depends on the technology.
I mean, all this stuff is, if you don't get a patent, what good?
Yeah, a couple of years.
Oh, it's more than a couple of years.
Well, it depends on the technology. If it's simple technology, it's a couple of years.
That's on average about 4 years.
No.
No.
That's probably a little longer.
Yeah.
But some maybe 4 years. Pharma,
Software
Could be, yeah.
many years.
Something
So it
Seven,
does depend. Yeah.
twice.
To get that discount rate, you mentioned it's like a 158-page report. That must have cost a phenomenal amount of money. I mean,
Yeah,
right?
it's expensive.
Now, I guess you gotta be a big company, huge company.
Well, it goes back to what's the purpose of the valuation. If you're looking for, $10 million in financing, or you're looking for a huge investor, you gotta weigh that. I'm not saying you need a 150-page report for every income type of cost evaluation. That would happen to be big. But to get those discount rates, you really need a CPA that knows his or her stuff to go through
I
this.
mean, what could something like that cost you?
It could range. It's thousands of dollars. Depends on who you use. This happened to be, it was Price Waterhouse, so it's a big firm. They charge an arm and a leg. But I'm sure you can find folks that are out there that do this kind of, small firm, maybe are on their own, they're much less expensive. Yeah.
I can imagine two variables that you would consider in this 150-page report. One would be inflation, and that would be one variable. The other would be the value of the currency with regard in relation to other currencies. Would it be asking too much for you to tell us what else did you consider? What else is part of a discount rate?
Oh.
Well, I could just add, for example, for a big company, they also expect a certain rate of return on their money that's greater than just the average bank rate. So they'll say it's gotta be more than this percentage. And then on top of that, they put in their overhead expenses and things for participating in the venture. So they've got a couple of things in addition to just external things like the value of money.
But the currency fluctuations was one, taxes was another one, what you just mentioned was one. I can't remember off the top of my head. I mean, you can look at the strength of the patents, kind of, is what are the scope of my claims? What's the likelihood that I'm going to get sued? I mean, are there other lawsuits in this industry, and kind of take that into account? I don't think there's any one set of factors that go into it, but from a business perspective, currency fluctuation, taxes, and what you're saying, definitely, cost of overhead and rate of return that's going to be demanded. Yeah, I mean, that all goes into it as well.
Thank you.
So cash flow. So you have your idea, you have your concept, you're trying to evaluate this on the income approach. Some questions to ask and look at. Is this product going to create a market? Is there an existing market, or is it going to expand the market? will this product give me some enhanced market share that I don't have? Will give me a whole new market share that I never had? Will I be able to sell this product for more because I've improved it? Sometimes you may have internal processes that you come up with that are patented, and it may reduce your capital expenditure. You do something, GM, they come up with a process that makes cars a hell of a lot faster for a lot cheaper. They're not gonna license that out, they're gonna use it internally, but it has a value to it that they can determine. Reduction in risk of litigation. You can look at, now I have a series of patents, a family of patents. Other companies may have similar patents. You now have maybe reduced your risk of litigation because you have a bit of an arsenal that they may be less likely to now come after you. And obviously, the royalties generated over time. So, one challenge in the cash flow method is apportioning cash flow to what your new patented product or technology is. So a product may have a lot of different technologies in it. What part of, say it's worth $100, what part of that $100 is attributable to your feature, your concept? And how do you apportion that? You need to value your portion to do this fairly. So I was talking to somebody the other day that said, when I get the iPhone 6 because I really like the camera. So got me thinking, just to kind of use that concept and that example to walk through this. Let's say you own camera technology. You're so fortunate to be able to license that to Apple, and you are going to supply the technology for their camera for the iPhone 6. And there's your external monetization strategy. And you can retire. So what's the potential cash flow generating that can be generated from licensing those royalties for the camera technology? A couple of ways to look at this is in a litigation setting. Let's say you were going to sue Apple because they're using your camera technology, and you won. You won on liability. They infringe. Part of that litigation is you have to look at damages. How much now do they pay you? And the law, patent law splits that up into two areas. Either you get reasonable royalties or you get their lost profits. Lost profits is a very difficult analysis, and I just raise it so you know, it's really kind of a but-for analysis. That product would not have sold but for your technology, so you're entitled to all the profits. It's certainly unlikely in the iPhone 6 scenario, but for purposes of this example, I want to walk through this valuation using kind of a reasonable royalty analysis and give you a sense of how this works. So a typical royalty calculation is your royalty base, say the iPhone 6 or whatever the widget is, cost $100. Your royalty rate is 5%, and it's multiply that times whatever the number of units are over whatever course of time, quarterly, yearly, whatever it may be, and that's what your cash is, your general inflow of cash. One of the big questions is, well, what's the royalty base? And that could have will have significant effect on what your valuation is. The royalty rate obviously does too, but what the royalty base is really what you want to look at. The general rule is that the smallest saleable patent practicing unit is the royalty base. And it's not the entire product. So my iPhone 6 example costs $1,000. My camera technology, certainly I'm not going to be able to look and use the $1,000 as my royalty base and take 5% of that, because that's not the scheme of the technology that's in the iPhone 6. My camera technology plays part, but there's a whole lot of other stuff going on there. So and that's in litigation and evaluation, that's a difficult thing to try to figure out. Where's my place? What's my royalty base? There's one caveat to that, and that's this entire market value rule, which the courts go back and forth on whether they like it or they don't like it, but at least I want to point it out, is if your patented feature is so good that that's what's drawing the demand, that's why people are buying this product, then your royalty base could arguably be the cost or the price of the whole product. So now you're getting a piece of the whole pie, not a piece of the smaller pie. And that's, so in our iPhone 6 example, does the camera technology drive demand? Is that why everybody's out there buying these things? It's not the case, but it's just an example for the iPhone 6. It's for valuing products and the income approach, you really need to be able to show and support that your feature, whatever it may be, is driving demand. To have, if you have investors that are going to look at this valuation, litigation, you're going to have financing based upon this valuation. You better have a good reason and some evidence to show that it's your demand, it's your product, your feature that's driving that demand. Maybe more of a litigation issue, but in order to prove that you're entitled to the entire market value, you have to show that demand. Another way to look at this is, let's just go back to reasonable royalty and say, so you don't even have to show this kind of enormous demand based on your feature, but you can say, my royalty rate should be 8% of this smaller now royalty base. So increase the royalty rate, but look at the same smaller royalty base. But you have to have some support for that too. And you can go back and look at these LES types of surveys where you see comparable markets and what the royalty rates are. And I'll tell you, in the life science one, it's very interesting. They have a chart in there where over the course of these 150 or some odd deals that they looked at, they have a chart of royalty rates, and it goes up pretty substantially from 1% to 5%, maybe 7%. Then it drops off pretty substantially. And there's a couple after 10, 12, 14%. But 5 to 7%, that was kind of the sweet spot. And you can really see that. And if you're in the pharma area, the life science area, you can use that and say, look, I would be entitled to this kind of 5, 7% range. So the next thing to look at is, how long am I going to get this cash flow? How long is it going to last? And a common error, and I go back to the Shark Tank on this, is if you have a patent, the valuation, I've seen them say, valuations, I have a patent for 20 years, so I can evaluate over 20 years. Well, nothing lasts. Most things don't. Technologies don't last 20 years. If you're in the electronics industry, you get a couple of years and you're done. The patent's still in effect, but it's obsolete. You're done. Pharmaceuticals, much different story. We all hear, when these blockbuster drugs go off patent, it makes the news. Not so much for electronics technology. So you have to understand what your market is, what your technology is, realistically, how long is that going to last? All right, can you flip? So economic life of the asset may not be the same as its legal life, and typically is not. So you need to be fair on that. So we're saying technology covered by the patent may become obsolete, products may become obsolete, so you need to. So consider not only the product life cycle, but the flexibility of the invention. What I mean by that is, your product may be selling into the automobile industry, but your patent may not necessarily be limited to the automobile industry. So you may be able to kind of turn, and although whatever your product is may be obsolete, becoming obsolete in the automotive industry, maybe in the aircraft industry, it offers a whole new application. And if your patent claims are broad enough and they're not limited to one particular application, you got a whole new revenue stream that you can go after. And that's where the key comes, or the patent prosecutor, and working closely with their patent prosecutors so that they understand the breadth of what your scope, what your claims can be, is hugely important in really looking at and monetizing patents. And through all of these different processes, whoever's looking at it needs to look at the scope of the claims, obviously, to understand if it's not all that difficult to get a patent if you're willing to add in enough claims to make the claims narrow enough to be novel and non-obvious, but they may be so limited that it's extremely easy for a third party to tweak it a little bit, take something out, and just design around it. So that's the balance. So then, I know how much I'm generally gonna make, I know for how long I may generally make it, the cash. What are the risks? What am I up against? What are the likelihood I'm actually gonna get anything in the door? So one element to look at is, will litigation be necessary? Is it likely I'm gonna be in litigation? If you are in litigation, if you're gonna assert your patent against a third party for infringing, that patent will be met with a challengeable, guaranteed 100%. So you put the validity of your patent at risk every time you litigate and enforce this patent. You're up against patent challenges by third parties. Now at the patent office, there's now a number of different ways to challenge the validity of the patent. So you need to understand kind of who your competitors are. What's the likelihood that they're going to take these types of these steps to challenge your patent? Are your competitors behemoth companies that will spend the cash to try to make this patent go away? Maybe, and that's something you can look at and measure. One exercise, and we've gone through this, is to look at the freedom to operate and what other patents are out there, and that's good from a valuation perspective and explaining to whoever may be investing, explaining to the bank who may be looking for financing. Say, I've done this search. There's nobody else out there that's really in this space. Here are a couple of patents, but they're different, and here's why. I think that has a tremendous amount of value. And then one other likelihood or thing to be thinking about in the risks and likelihood of getting any cash here are trade secrets. What I mean by that is there anything else that you need to make your product, your practice, your method, that you may need to go out and get from a third party? Or do you have everything, is everything covered by your patent? So we had a lot of questions on this. It's a complicated area, but it's an important one. And so the reliability of the approach depends on the selection really of this discount rate. What goes into it, how you figure that out. Because that discount rate really is taking into account the risks and discounting it to take into account those risks as of today, if that's the data you're measuring it by. The higher the discount rate, the lower the value, and vice versa. It's extremely complex. It really should be done by CPAs, people that have expertise in this area. Typically, you don't see patent lawyers. We'll help. We'll give input. We'll look at patent claims. We'll look at prosecution histories. But it's typically not patent lawyers that are coming up with discount rates. It's CPAs with the assistance of us. We opine on validity and infringement. They do business in the discount rate side of it. Flip. So then, a couple of things to be aware of for the New America Invents Act and how that may affect valuation. So now we're first to file. We're no longer first to invent. When it was first to invent, you never knew if there was somebody out there that invented before you until you know about it, until they bring it to your attention. Now that's changed, and for the most part, you can look, you can measure your filing date against the filing date of others, and so it does help in that sense in valuing what you may have. A new process, which you all may be familiar with, is the inter-party review process. It's very popular, probably going to continue to be even more popular. It's basically a small, I shouldn't say small, an administrative trial down at the patent office. There's discovery, there's argument, there's a hearing. It's different than what the process used to be. It used to be an ex-party process where you can basically, what you can still do is you send in as a third party your prior art to the patent office and say, hey, you should reopen this prosecution because these patents are invalid over what I'm now sending you. Once the patent office agrees, once you get that agreement from them, you're kind of out of it. You just stand back and watch. There used to be another process where you could get involved and submit things and be part of the prosecution, and this kind of replaced that. Now it's at a trial. Yeah.
Is that everyone with those seeking to void patents or avoid patents?
To avoid it by voiding it. Yeah, so if somebody sees your patent, they say, hey, this is a big, big problem for us, this may be a path that they take. Hopefully they call you and try to negotiate something different, and maybe it's got value if you sell it to them or license it to them.
This IPR thing, you're saying this is done in the patent review process before it issues?
No, it's done after. So it's patent issues, then third party files this inter-party review application. If it's all accepted, now both parties, the patentee and the third party, are before the patent office, now making their arguments.
Who pays for that?
Either side. Not cheap.
Who does, I'm sorry?
Whoever's filing the inter-party review, yeah, it's a litigation essentially.
Yeah, but, so you have to go, I mean, what kind of money for lawyers, but they're
Yeah, yeah, it's an expensive game. Yeah.
You done?
Well, I mean, you have to fight it the best you can, but if you're a large company and you're looking at a patent that's a problem is owned by a solo person or a small company, that you play into the analysis. Say, look, let's throw everything at it.
What about, what if the inventor doesn't get the letter that states?
Well, it's a huge filing, and they will get it. They do get it.
They have to be served.
Yeah, it's a gigantic, complex analysis that you need to present to the patent office to get them to agree to go through this process. So you need to prove that.
No, what I'm worried about is what about, the notification that the inventor gets that this is happening. And one of the fears I would have is that the inventor doesn't even know they bring this up, and they go, oh, no one showed up to court because the inventor doesn't know what's going on.
Yeah.
And then later on, he finds out it's been invalidated. So no one told me about the court date. I mean, how did they notify? Do they have like certain notification procedures?
There are processes to make sure that you've been notified. And frankly, if it's now a mini trial, I mean, they're not going to default you if you never knew about it. Even if they did default you, come back and say, look, I never got the notice. I never knew anything about this.
Okay.
So not,
Have some of these.
the nice thing is,
Yes.
the patent office is gonna be collecting
They started a couple
fees
years
from you
ago.
every year, so they're gonna be reaching out to you. They'll know
Some
how
of
to
them are
reach
now
you.
starting to go through up to the federal circuit, and so they're starting to make their way through the system. But it's a popular mechanism.
Okay, so it's appealable outside of that.
Yes, I think the decision to not undertake the IPR by the patent office, I believe that is not appealable. That's final. When I just read an article on this, that there's a very detailed process to file this. If you miss something, the patentees now are really checking every single margins and font size and all that, and if they miss it and they do something wrong, patentees are filing motions to dismiss based upon you follow the rules. Patent office may dismiss it, can't appeal it, you're done. So that's a strategy that patentees would take. Yeah.
Who's the judge? Are judges judging, or is the patents examiner judging?
It's
Is it arbitrator judging?
administrative law judges
Administrative law judges.
at the patent office. Yeah.
Well, obviously have a lot of background in patent.
Yeah.
Have there been much of this going on per patent, or is this?
There's a lot. Yeah. I mean, when it started, it took off, and it's pretty successful in validating patents and claims. Frankly, the inter-party, what was the old inter-party process, was pretty successful too. This is, I don't know what the exact percentages are, but it may even be more successful.
If one company goes through that process and loses, can other companies still file their own suits and try the same process again, or are you safe from going on from there?
Say if they base their request for the inter-party review on the same stuff that the other one did, then you probably didn't get denied. We'll say, in the inter-party review, if you lose, or if your arguments aren't accepted, you may be limited in what you can do in litigation. So if you sue on that patent, if it survives the day, and you sue on that patent, you may be precluded from making the arguments that you made at the patent office because they didn't agree with it. So there are some ups and downs from the third party side, from deciding, do I go to litigation? Do I file one of these? Do I do both? And what you may see, or what you do see, is patentee files lawsuit, asserts the patent. Third party defendant files one of these early on. It goes to the federal judge and say, hey, I filed these inter-party review, and the patent office accepted it. They're gonna review the whole thing. I want you to stay this litigation. Let's see what the patent office says about it. So the patentee's now got to sit for 18 before they even restart the litigation, assuming they make it out.
So it's a good way to delay it back.
Yeah,